Hey guys, this is Joe748 from Blackjack Apprenticeship, and I'm here with SD1. How you doing, SD1?
What's up, Joe? Doing great.
And we have a very special guest for you guys today. Stef Casella is a former federal prosecutor and one of the nation's foremost experts on asset forfeiture and money laundering law. With over 30 years of experience at the U.S. Department of Justice, he played a key role in shaping federal forfeiture and money laundering statutes, litigating major cases. Now he's the CEO of Asset Forfeiture Law, which serves as an expert witness and consultant while authoring influential legal treatises and publications on financial crime. Thanks for joining us, Stef.
Well, you're very welcome. I'm glad to be here.
Nice. So what made you want to get into law?
Well, I got my undergraduate degree in applied physics, which makes no sense at all. And after 4 years of that, decided that maybe something that I could really understand a little bit better might be a good way to go. So I applied to law school, and that turned out to be easy in comparison to quantum electrodynamics. Thank you very much.
Yeah, I like how you say that law is easier to understand than anything else.
Wow.
When did you choose the sector that you went into eventually? Did that come way later? Or?
Nobody sort of, grows up wishing that he will become an asset forfeiture and money laundering expert, right? I went to law school because I was very interested in public policy. It was in the late 1970s. There were many, many things about the law that I found interesting, and I found myself attracted to constitutional issues. And so I was, sort of interested in the criminal law where those constitutional issues come up. I got a job as a prosecutor because that seemed to be a way to follow that interest. And I served as a local prosecutor, and then as a state prosecutor, and then as a federal prosecutor. Along the way, I had a chance to take a few years out of the Department of Justice and work for a U.S. senator, and got involved in drafting some of this legislation, which was really good experience for me. Went back to the Department of Justice and spent the rest of my career. And by that time, it turned out that money laundering and asset forfeiture were the new thing. It was the shiny new object that no one knew anything about. And I was sort of interested in doing the new thing that no one else knew anything about because I could learn it. I could then help develop the law. I'd worked on some of that legislatively when I worked for the senator. So here was an opportunity to see something from the ground up. The government was beginning to develop an asset forfeiture program to make asset forfeiture one more tool so that not everyone had to go to jail, but sometimes you could just confiscate the assets, and that would be a sufficient punishment. The law was all brand new, and money laundering, too, was all brand new. And so it was just an exciting time to be there at the beginning of something.
Wow. So what was the earliest cases of asset forfeiture?
It's an interesting question because there's two answers. One is that asset forfeiture has been part of the U.S. federal system since the late 18th century. In the very first Congress, they passed asset forfeiture laws to allow the recovery of pirate ships and slave trafficking ships and smuggled cargo. So the idea was we don't have the bad guy in our custody. He's somewhere else. Maybe he's in the Caribbean, maybe he's in South America, maybe he's in Europe, but we do have his ship and we do have his cargo. So what is a way of enforcing the law when you don't have the wrongdoer in your custody to prosecute criminally? And the answer was bring the action naming the property and then prove the crime and the connection between the property and the crime that way. So throughout the 1900s, there was forfeiture involving smuggling and then later when Prohibition came in, sort of whiskey stills and that sort of thing. And that's why the cases continue to have what sound like funny names. The United States versus, one sailing ship named the whatever was the original way of doing it because you were going after the ship, not after the ship owner. And then later, United States versus, 75,000 crates of whiskey because you're going after the whiskey, not after the whiskey distiller. So to answer your question, it started out very early, but why are there two answers? Because in the 1970s, Congress figured out that this tool, which had been around for forever, and which was used in sort of niche areas, could be applied to drug trafficking. And so you begin seeing in late 70s into the 1980s an explosion in the number of forfeiture cases where they had been, something rarely used, but used effectively in a small niche of cases, now being used in all the drug cases. And then that expanded still further. 25 years ago, Congress reformed the forfeiture statutes to put the burdens on the government and give more due process. So it made it harder to seize property, but at the same time, they expanded the scope so that it's not limited to smuggling and it's not limited to drug trafficking, but now it applies to almost all crimes. The proceeds of fraud, the proceeds of human trafficking, the proceeds of illegal gambling can be seized through forfeiture. And it can be done as part of a criminal prosecution or, as was done as long ago as the 1780s, as a separate civil matter.
I just want to review what you just said. So the unique thing about asset forfeiture is the defendant is not the person, it's the property itself they're going after. To your point, there were more protections and more due process put into place, which sounds like a good thing, but they made it more broad and more sweeping. So have there been an uptick since they made it more broad in civil asset forfeiture cases?
Yeah, well, if you're talking about in terms of the number of dollars recovered, yes, because in the last 25 years, now that forfeiture applies in white-collar crimes, which it did not for the most part previously, you're recovering millions, hundreds of millions, even billions of dollars from the Bernie Madoffs of the world and banks that get involved in laundering money for international bad guys and in recovering the proceeds of graft and fraud and bribery that occur overseas, but the money's invested in the United States. So there's a lot more money being recovered these days because of the greater scope of the kinds of crimes to which the forfeiture laws now apply.
So with that more broad-based approach, but more due process in place, it seems like from what I read, the country as a whole is maybe leaning more against civil asset forfeiture. It seems to be the temperature that I take, but it's kind of like pocketed. I know the state of Michigan, for instance, seemed to embolden their civil asset forfeiture abilities. And I might be reading this wrong. You can correct me. But it seemed like from what I read that in Michigan, they really don't even need a reason to take cash, just kind of suspected.
Well, every state has got different laws, but I would be amazed if it turned out that they didn't need any kind of proof, because that would violate concepts of due process, and that would be a federal constitutional violation. Maybe it'd be helpful to explain the difference between civil and criminal forfeiture.
That would be great.
So if somebody is convicted of a crime, he's a drug trafficker, he's a child pornographer, he stole money in an investment fraud scheme, he has a cryptocurrency, money laundering, tumbling business, whatever it might be. If he's convicted of the crime, then as part of his sentence, the court can order him to forfeit the proceeds of the crime, and in many cases, not all, but in many cases, the property that he used to commit the crime. Did he use his truck to distribute the drugs? Did he use his computer to distribute the child pornography? So the criminal forfeiture is part of his sentence. The civil forfeiture is what the government uses when it doesn't have a criminal case, or sometimes it's in parallel to a criminal case, but there's a reason to do the forfeiture part civilly. Now, some of those instances are obvious. The guy is dead, but you still want to recover the property and get it back to the victims. Or he's overseas and you can't get him back, he's a fugitive. Or he committed the property overseas, but he put the money in the United States. But there's some more subtle situations also, and those would include he's already been convicted of a state crime and you want to recover the property federally without prosecuting him a second time, and so forth. And one of the instances in which they use civil forfeiture is when the interests of justice just don't require criminal prosecution. My favorite example of that is a woman in Seattle, Washington, some years ago, who, knowing that her son was a convicted felon, nevertheless thought that buying him 5 firearms for his birthday would be a nice thing for mom to do. And she falsified the records showing that she was buying them for herself when she was actually buying for her son, a convicted felon who's not allowed to purchase firearms. Okay, so now you find out about that. What do? Do you, A, give her a gold star for being a great mom? B, do you try to convict her of a felony and put her in federal prison, or do you just take the guns away? So in that situation, the government elected to just bring a civil forfeiture action because you don't have to prosecute the case. You can just take the guns. And that's done a lot with respect to minor offenses. Now, you point out that there's some popular unhappiness with civil forfeiture. That's true with respect to one particular way in which the statute's used. I don't hear any objection to using civil forfeiture to take money out of a bank account that was being used to fund the North Korean nuclear weapons program, or trying to take money out of a bank account that was opened by a corrupt president of Nigeria who stole $4 billion, or many, many, many other instances involving theft of intellectual property, involving, I mentioned the child pornography cases, the cryptocurrency schemes where the money is found in a crypto wallet, but you can't find the bad guy because he's off in Asia someplace. Nobody objects to any of those. What people object to is that if a local police officer seizes cash from a motorist and it's forfeited, then the local police department gets to keep 80% of the money. And notwithstanding the fact that the same due process rules apply in all of those cases, the government has the burden of proof. The government has to prove the case, has to prove that a crime occurred and that the property was derived from a crime, has to give you a right to a jury trial, has to reimburse you for your attorney's fees if the government loses, has to provide for an innocent owner defense if the property really belonged to an innocent owner. Notwithstanding all of that, the notion that the police get to keep some of the property, 80% of it, just strikes people the wrong way as providing an improper incentive. I could explain why that makes sense from a public policy point of view. I certainly understand why the perception is negative, but that's the part of civil forfeiture that people object to. I think not the absence of due process, but the fact that the police get to keep some of the money.
Yeah, there's an error. Like you said, it feels like it's incentivizing police departments because keeping 80% of the funds, like just saying that out loud, just doesn't feel right or sound right. And I'm sure that there are public policy arguments to be made for that in the right circumstances. Well, that helps fund our law enforcement agencies. And if you support those, that could be a good thing. But it still feels icky when you say it.
Right. No, that's right. And perception is sometimes 90% of the story, right? If people just don't feel right about it, you could spend all day describing all the due process protections and they still say, yeah, but why are the cops getting to keep the money? I mean, it's absolutely true that it provides an incentive. I found out when my kids were teenagers that I got much more success in getting them to mow the lawn if I paid them $20 than if I didn't pay them $20. Surprise, surprise. And the reason the federal law enforcement authorities like this equitable sharing, which is what we're talking about, program, is because it incentivizes police departments not just to go out and seize money. That's not the objective. It's to get them to cooperate with federal law enforcement because this is a very, very big country and very few federal law enforcement agents, and they need the cooperation of state and locals in order to get their job done. And the way you get cooperation is say, hey, if you do some forfeitures, you'll be compensated by being allowed to keep a part of the money. That's the good side. And the bad side is, of course, the public perception that that doesn't sound right. But that's the story. But nevertheless, from the lawyer's point of view, what we're mostly concerned about is, okay, so the cops had an incentive. Do you still have a right to defend yourself? Do you still have a right to get your property back in a reasonable procedure in which your due process rights are protected? And that's the question that I focus on.
When you say they get to keep 80%, but once they seize it and then everyone goes to court and it finds out that, there was no crime being committed, what happens to the 80% that was given away to the local? Do they have to give it back?
Actually, they never get it until the case is completed. So it's important to understand the stages of a forfeiture case. Seizure is to forfeiture the way arrest is to conviction. Okay? The seizure starts the process. The money remains in an escrow account until there's ultimately a judicial determination that the property is forfeitable, or until the time for anyone to complain about it expires and the property is forfeited by default, which happens actually most of the time.
How long is that time frame?
So if a seizure takes place, the government is required to advise the property owner within 60 to 90 days. There's some, depends on the circumstances stuff, but sometime between 60 and 90 days of the seizure, they have to advise the property owner that the property has been seized and that if they don't act, it's going to be forfeited by default. They've got 30 days in which to act. And by acting, I mean they simply have to send a letter with a 55-cent postage stamp on it that says, I object to the forfeiture. If they object, this is the civil cases now. If they object, then the government has to file within the next 90 days an actual formal complaint in court, which starts the litigation, which can lead to ultimately a jury trial or resolving the case by settlement or some other resolution. And at the end of the day, there's either the money gets returned or with attorney's fees, or it gets forfeited. And only then, only once it's the government's property and not in an escrow account, does it get shared with any police department.
Back to your definition of civil and criminal. It is civil if there is not an actual criminal arrest made, but a suspicion of criminal activity that would fall under civil.
That's right. So it's just a suspicion of criminal activity. The technical phrase is probable cause. The same level of suspicion you have to get a search warrant. The same level of suspicion you have to get an arrest warrant to arrest someone. The same level of suspicion you have to have in order to seize property. You have to have probable cause to seize, and then you have to prove the case, prove the crime and the connection between the property and the crime by a preponderance of the evidence in a trial or other civil proceeding in order to get a forfeiture order.
Okay. So, I mean, this is exactly why we're having you on. We really appreciate it. As I kind of laid out to you, you asked a great question, like, I'm confused as to how this applies to you guys and what you do. And I explained it. And briefly, advantage players, professional gamblers, advantage players are what the casinos like to call us. We are always afraid that we are at risk of this. And we have friends that have gone through civil asset forfeiture cases because of the fact that we carry large sums of cash, whether we fly with them or we drive with them. And it's always, we run trainings and boot camps, and this is a topic that always comes up when we're discussing this with our future card counters and future students, because there are nightmare stories that have occurred and we are doing nothing wrong. We are abiding by the law. I mean, I actually have I have an LLC, I have a business set up. And even with a bunch of proof that this is in fact what we do, the police officers seize the cash, and then we have to go through the entire process. And there's been some nightmare stories about even Colin, who actually, founded Blackjack Apprenticeship. He had one across the border. It was Canada, right, Joe? Were they traveling from Canada? Mm-hmm. They had seized funds, and at the end of it, they did in fact get it back, but they did not get 100% of it back. The government kept a small portion. I don't remember what it was. Do you, Joe? Was it like 10%?
Well, it cost $10,000. I think $10,000 minus $10,000. They got it back minus $10,000. So it was $100,000 they seized, I believe.
That sounds like a compromise settlement as opposed to any calculation that was based on any facts. It sounds like, well, let's settle this, fellas, and we'll keep $10,000. You get the rest back. I don't know. I don't know the case, but that sounds like what that is.
So in that case, the lawyers basically and the client, and well, I guess the client was the cash. It's kind of weird. The defendant was the cash, but Colin and the team had to have, I guess, agreed just to get it done and get the cash back is probably what happened. But that doesn't feel great either. But I guess lengthy litigation to prove your innocence of no crime being committed, you kind of have to weigh it.
Well, a couple of things. First of all, just on the defendant being the cash, it's not like the money did something wrong and has to defend itself in court. This is it's a convenient way of letting the world know that the government thinks that this pile of cash is forfeitable because it was derived from or used to commit a crime. So the way to tell the world that this is the property that we're trying to forfeit is to name it in the caption of the case. The United States versus $65,000 in cash wrapped in rubber bands. Okay. And let me give you a typical scenario before we get into the gambling context, just so you understand what the police are thinking. So drug dealer's been murdered. His body is lying in a bloody pool on the ground, and there's $90,000 in the car next to him. And they think that the $90,000 just might have been involved in a drug deal. And they would like to recover that money, but you can't prosecute the dead guy. So you bring a case called the United States versus $90,000, and you see who wants to contest it. Maybe his widow contests it. She claims that the property was marital property. Maybe his daughter contests it. She says she's the heir to him. Maybe his business partner contests it, says, wait a minute, we weren't in the drug business. We were in the lawn mowing business, and I should be able to get the money. Maybe some guy to whom he owed a debt, or his ex-girlfriend who wants child support claims the money. I mean, all kinds of people can come in. The idea is you name the money, you state the reasons why you think it's forfeitable. There was a drug crime and this money was involved in the drugs, and you let all these people come into court and make their case. They get to put the government to its proof. The government has to prove the crime and the connection, but they all get to put the government to its proof if they have a real interest in the property. And then if the government wins, it keeps the money, and if the government loses, it gives the money back. So in the scenario you're describing, motorist is driving across, South Dakota, and he's stopped for a traffic violation, and one thing leads to another, and the police find $65,000 wrapped in rubber bands in the console of his car. Now, there's nothing illegal about driving across South Dakota with $65,000. And so nobody's being arrested here. But if the money is criminal proceeds, then it is subject to civil forfeiture. Okay, so what are the cops trained to look for? Well, they look for whether the quantity of cash. The average person doesn't drive across the country with $65,000 in cash. He uses a check, or he uses a debit card, or he uses wire transfer, or he uses Venmo, or he PayPal. He does something a lot safer than driving around with $65,000. So the quantity of currency already raises suspicion. Second, how is it packaged? Is it, wrapped up in rubber bands, concealed in a trap in the car? Is it in glassine sealed bags? Has it got coffee grounds on it to throw off the scent to a drug dog? How is it hidden? And the third thing that they look for is, what kind of stories is the guy telling? Are there two guys in the car and they tell inconsistent stories? Is he telling a story which makes no sense? I was on my way to California to buy a boat, but I don't know who I was going to meet. I don't know what kind of boat I want, and I've never had a boat. Has he lied to the police officer? Has he told different stories over a period of time, in the course of the conversation? Does he have a rental car agreement that shows that he rented the car in Boston and he needs to return it tomorrow, but he claims he's on his way to Las Vegas? All of these things are things that arouse in the mind of the police officer suspicion, sufficient to establish probable cause to seize the money so that we can fight over it. Now, the problem that you guys have is that the most common explanation the drug dealers give for why they're carrying that money is they were going to a casino to gamble. Okay? So that when your people say, oh, I'm carrying all this money because I have to deal in cash because I'm going to a casino, police officer says, okay, check, probably drug money. Now, that doesn't mean your guy's lying. It's just an indication that they know from their experience is one more indicator that this money could be drug proceeds. And if it is, then they seize it. They give you a notice, and then you've got your time to make a claim and fight about it in court. What you'd like to do is to avoid the original seizure by being sufficiently convincing to the police officer that, no, I really am a guy who goes to the blackjack table and carries a lot of cash.
Correct.
So how do you do that? That's your question.
Yeah, it is. It's interesting. You brought up a couple points that law enforcement looks for. We have a friend that does what we do, Levi Mitch, and he was pulled over, and two things saved him, he thinks, from actually having the money seized. Number one, his brother is actually law enforcement, and they were able to get them on the phone with him. That helped big time. And number two, one of the things he attributes to him being better off is that he did not have his cash banded with rubber bands. They were strapped with bank straps.
Yep, that makes a big difference. The cops all know drug dealers wrap their money in rubber bands, usually in piles of in $1,000 increments, often with a note that says, "I owe Jose this much," and so forth. And they often put it in a sealed bag, and they have fabric softener sheets wrapped around it so the dog can't smell it. The dog can smell it. They don't realize that, but they think the dog can't smell it. All of that. So if I were stopped with a large quantity, I mean, it's not going to happen to me because I've never got more than $20 in my pocket. But, if I were in the business where this was an appropriate way to conduct my business, I would make sure that I could show the police officer that it really came from a bank. So it's wrapped in bank wrappers. That's a big difference from wrapped in rubber bands. I've got a receipt from, the bank or from the ATM machine showing how I got it, where I got it from. I also would want to be able to show that I have a logical itinerary. Here's my reservation at the hotel in Las Vegas or wherever I'm going. Here's my rental car receipt showing I've got the car for 2 weeks or I'm driving my own car. I mean, the opposite of all the things that the cops often see. The phony story, the guy who says, "Oh, I'm on my way to California to see my cousin. What's your cousin's name? I don't remember, but my mom knows. Can I have your mom's phone number?" Gives the cop the mom's phone number, call mom. Mom says he doesn't have a cousin in California. I mean, these are real cases. That really happens. So doing the opposite of that. Here's my story. It's coherent. It's straightforward. I've got documentation. I've got reservations. I've got a history of doing this. I have, receipts from the bank. This is my bank account number. Anything like that would go a long way toward persuading the police officer. Now, if you fail to persuade him, that doesn't mean you lose. That just means now we're going to go to court and litigate over this. But at least most of the time, you should be able to persuade the police officer that I'm not the guy you're looking for. Sort of like that scene from Star Wars. These are not the droids you're looking for, right?
And the scary thing about this is, especially earlier in your career, oftentimes you can be driving with what we call your entire bankroll or your operating budget for your business. So having that confiscated means you can no longer work because cash is nothing more than ammo for us to work. It's a tool.
It's more than an enormous inconvenience. It borders on a violation of your property rights to deprive you of your property at a time when you needed to keep your business going. And that's a real concern. And that's why these things have to move along fairly quickly. Again, just to understand it from the police officer's perspective, when they make these seizures and they send out the notice, 80% of the time, nobody responds. 80% of the time, no one sees it in their interest to complain about the seizure. Why? I mean, if I send out a notice that says, on the 1st of May, we see $65,000 wrapped in rubber bands, 2 kilos of cocaine and a loaded handgun, would you like to challenge this? 80% of the time, nobody does. But when there are challenges, then it's undeniable that it's expensive to litigate in federal court. I personally, and this is just my personal view, think there ought to be sort of a minimum threshold on the cases that go to court, because who's going to hire a lawyer to defend against a seizure of $3,000? And I wouldn't, even though it's just not right that I lose my money because I can't afford to litigate with the government. But when we're talking about large sums of money, and there is probable cause to believe that it's derived from a crime, then the right thing for the police officer to do is to make the seizure and then to follow all the process and to get the case started. And then we could talk about kind of what happens after that, if you'd like.
I think that's the biggest concern, is because, some of our members don't have a large bankroll. It could be $10,000, $15,000 total. And if it ends up costing $10,000 to defend it, or let's say they have less, let's say they have $5,000 bankroll and it costs $10,000 to defend it, then they're kind of screwed.
Yeah.
Do you know, with the local seizures, what percentage of them have been cases that have been, less than $5,000 or a small amount of money?
That varies from state to state. When I went to the U.S. Attorney's Office in Maryland in 2009, they were still seizing $3,000. And I thought, hey, guys, let's come up with a more reasonable number. And we never got it up too much higher, but I believe the government today has a higher threshold. I don't know what it is. I haven't been in government in 10 years, but the threshold in South Dakota is lower than it is in Miami. I mean, if in Miami they brought every case involving $10,000, they wouldn't do anything else because that's the standard way of doing business in Miami is be driving around with a lot of money in your car. But the seizures themselves just start the process. And if it turns out that you've convinced the police officer by being totally straightforward with documentation right there on the scene, here's my bank account information, here's the receipt from the bank, here's the day I withdrew it. I mean, so much is common sense. All the police officers know that they have stopped people who've said, oh, this is the money from my insurance settlement or from my girlfriend's insurance settlement. When was that? In July 2 years ago. Oh, and where's the money been all that time? I keep it in my sock in case I see a truck I want to buy. I mean, nonsense like that is what gets the money seized. But on the other hand, I was at my bank yesterday. Here's the receipt. This is my bank account number. This is the amount I withdrew. Here's the money still in the bank wrappers. And I'm on my way to this hotel and I have this reservation. That's a plausible story. And it's less likely to end up with a seizure.
Well, and a lot of times that's another issue that we have because it's interesting. You said earlier, like the cash didn't do anything wrong, but in today's day and age, it's almost as if cash is doing things wrong because it's just looked upon as people don't do it. So if you have large sums of cash, you're obviously doing something wrong. And the banks are not excluded from that. We rarely take money out of a bank because it's very difficult to get your cash out of a bank. So a lot of times we keep a certain amount with us at all times because we have to have it to operate in the casino environment. But that does, I mean, you can buy straps on Amazon, cash straps, and I strap my stuff that way too. I'm curious, along those lines, there's often been something said in our world, especially when flying. Is there any truth to if you put your cash in an envelope, address it, and put a stamp on it, that it is not allowed to be looked in?
I don't think so. You're referring to a rule about not searching the mail without a search warrant, but I'm not sure that it's considered to be in the mail if you're driving along with it in your own car and you've just decided to put it in an envelope and put a stamp on it. That's different from going in the mail system as it's moving through the mail and opening up people's mail. They cannot do that without a warrant, but I don't know. Every case is going to be different on the facts, but I don't think in the situation where you just happen to be carrying your money with you with a stamp on it, that's in the mail for that purpose. But back to your other point, I could show you tens of cases in which a judge has said in ruling one way or the other that the ordinary person in business does not carry tens of thousands of dollars in cash, that that's an extremely unusual event. And that's why it is a factor that weighs in favor of the seizure. That doesn't mean that you don't have that one instance where it is reasonable to do it, but it explains why it is considered to be an indicator. And as far as the banks making it difficult to get cash out, I don't know what that scenario is, but if you're getting money out of the bank, the one thing to avoid doing is taking it out in $9,900 increments.
Right. Avoid a CTR.
Yeah, because you get the CTR filed and have it with you, because bad guys don't do that.
Right.
Bad guys, they think that if they keep it under $10,000 and no CTR is filed, that they're in the clear. When the fact of the matter is, that's a red flag. Taking out $9,900 is like waving a red flag, saying, "Hey, come look at me. I'm doing something wrong." Right. So, making sure that you just take out what you need and doing it in a reasonable way, not $9,900 on each of 3 successive days. That's an indicator.
Yeah, and to the community, I mean, I specifically deposit above a CTR amount, so I am CTRing on a regular basis. So if I were ever need to grab those records, or in a different scenario, an audit, I don't care about getting CTRs. Here's a bunch of them. It's not a big deal. It's a normal course of business.
Yeah, so that distinguishes you from 99% of all the drug dealers in the world.
Yeah, I guess. So my attorney, any good attorney that is defending you or tells you about a particular scenario where you're being questioned by police will tell you, don't talk to cops. And I think that in this particular scenario, it sounds like it definitely would behoove us to just be completely transparent and talk to the police. But at the same time, there might be a little bit of a question. For instance, if you get pulled over because you were speeding, the cop is trained and allowed to lie, but trained to ask questions to get you to trip up or hear something conflicting so they can have probable cause. So I guess as an attorney yourself and one in expertise in this field, do you think it would be better for us to essentially just remain quiet, answer only the direct questions about what had happened, the speeding ticket, for instance, and do nothing else? Or do you think it would be better to completely say, hey, just an FYI, et cetera, and give the story?
And the best way I can answer that is however you decide to proceed, to make sure that you don't lie to the cop, because the worst thing that can happen is you say that you have no money in your car and then he finds it, or that you say you're on your way to this place and then it turns out you've got some pocket trash that shows that you're on your way to some other place, or that you give a story and then he immediately calls the guy you say you're going to meet and he's never heard of you. And as a practical matter, I would agree not to go volunteering a whole lot of information that would be possibly misinterpreted. But if you're telling a truthful story, there's nothing wrong with telling the truthful story. And it's pretty hard to avoid having any conversation. The police officer says, hey, how fast do you think you were going? And you say, I don't know. And then he says, where are you on your way to? Or if you just sit there and stare straight ahead and refuse to answer the question, where are you on your way to? Or where are you coming from? Or who's this fellow sitting next to you? I mean, that's not natural behavior for a person, right? You're not volunteering much. Oh, yeah. My wife sent me out for milk and bread. That's where I'm going. As long as that's the truth, I don't see any reason not to tell that story. It's the inconsistent stories. It's the patently absurd stories that get people in trouble, because it seems like people who have something to hide immediately concoct some story that they regret later because they can't back it up. And then they come up with a different story. And now they've got two different stories.
Yeah. Just a hypothetical. Let's say the cop asks me, do you have money in the car? I say yes, as not to lie. And then he goes, how much cash do you have in the vehicle? And I say, I don't want to disclose that to you. Is that enough probable cause for them to now seize?
No, it's not. But it's always going to be a totality of the circumstances. That's the legal phrase. And if on top of a whole bunch of other things, they always look at nervous behavior. They look at refusal to make eye contact, all kinds of things. Why is he sweating? And, why is he being evasive? And why is he forever looking over at the glove compartment like he's afraid I might look in there? All that kind of stuff goes into it. But no, if you simply say, no, I've got a lot of cash because I'm on the way to gamble, but I'm not, I'm not going to disclose how much I've got, that would not be by itself anything special.
The downside of that is that I'm sure that a lot of people would be extremely nervous having $100,000 that they legally have conducting a legal business, and they're worried about the cop taking it. So you can imagine that those same kind of mannerisms might come out, even though they're doing nothing wrong.
That's right. And to give them credit, the police officers have a tough time distinguishing between you're being nervous, you're going to lose your $100,000 in legitimately earned bankroll for your gambling, and the guy who's nervous that if the money gets seized, his cousin's going to get whacked in Mexico.
Yeah. What's like the least amount of probable cause that you've seen local law enforcement take in order to be able to continue with their seizure?
It's hard to say, but you have to add up all these factors about the quantity of currency, the manner of packaging, the inconsistent stories, the nervous behavior. And of course, if they have a drug dog alert, that's even better for the police. They often will detain you long enough for the dog to arrive. And then if the dog testifies that he can smell drugs, then that's another basis for the seizure.
Do dogs, in your opinion, are they trained to alert by command?
The dogs are very, very good and very accurate. And I have never had a case where I thought that the police officer was falsifying the dog's alert. The dogs really do. I mean, my dog sitting right here can tell me if there's a deer a block and a half away when the deer is absolutely silent because he can smell the deer. So the dogs are really, really good at that if they're properly trained, and the cops can't use the evidence from the dog alert unless they've got a certificate of training. So,
is there anything being done currently to sort of train local law enforcement to avoid like an unlawful seizure or one that was happening where they didn't have enough evidence actually to take it?
all the time. I'm the first to admit that there are cops who don't get the training and don't get the word. There are renegade cops, there are rogue cops, there are racist cops, there are racist greengrocers, there are racist ballet dancers. I mean, anybody can be the wrong guy in the wrong place at the wrong time. But in general, a lot of work is put into making sure that police officers understand the law. It's not in their interest to end up on the wrong end of a lawsuit for violating someone's constitutional rights. It's not in their employer's interest to have the government to return the property with attorney's fees. That's why the training is done, and I think it's done effectively in most places. But how many thousands of police departments are there in the country, and how many times is there an opportunity for something to go wrong?
So, from watching some of your previous interviews and videos, it seems like you think that asset forfeiture, both criminal and civil, are good tools that we need to keep around. Is that pretty correct?
Yeah,
pretty correct.
I think it's essential, as a matter of fact.
Okay,
yeah.
Essential. So, what do you see as things that could be changed to make it better? And have you seen cases in which you thought that it was handled improperly?
I've seen cases the government has lost because sometimes what appears to be the facts of the case turn out not to be so when somebody puts on a defense and shows that they really did have a legitimate source for the money, or that they were an innocent owner who didn't realize they'd been paid with somebody else's criminal proceeds. So just because the government sometimes loses doesn't mean there's something wrong. In fact, I think if the government never lost, there would be something wrong. The system is supposed to work in such a way that the government brings a case that it thinks it's righteous and provable, and once in a while, it doesn't work. Once in a while, the jury finds or the judge finds that the facts just weren't there. So I don't think any of that, the fact that there are occasionally losses, suggests anything other than that the system works. And I know there are people who disagree with that. There are people who think that if the government ever loses a case, that means that some cop did something wrong or some prosecutor did something wrong and should be punished. And I just don't believe that's right. Again, I'll just repeat that if the government never lost a case, then there would be something wrong with the system. It would be too weighted against the property owner. So the question to me is the system as structured, designed to get to the truth of the matter? And I think that it is. I mean, I personally worked on the drafting of these statutes, getting we think the proper balance and due process. You've got to seize with probable cause. If the seizure is illegal, the property cannot be used as evidence. You have the short deadlines for getting the case into court. You have the rights to the jury trial and the right to assert an innocent owner defense and the right to recover your attorney's fees if you win. All that's good. I think the one thing that makes it difficult to claim absolute certainty that this is a fair process is what we've already talked about, is the cost of litigating with the federal government. And so if it were up to me, I would raise the threshold so that it wasn't so hard to get into court. It's not an answer to appoint counsel to represent the property owner, because as I gave my earlier scenario about the $90,000 in the drug dealer's car, the wife, the daughter, the business partner, the guy walking down the street who watched the cops do the seizure, they'd all make a claim. They'd all claim they have a right to counsel. So you can't do that. It's just impractical. But by awarding attorney's fees to the winner, I think that's the solution to the cost. But even so, it's awfully expensive to litigate with the government. So I would raise the thresholds.
And how does that work? So let's say I have cash seized and I'm going through the process. I would think that I would have to be paying my attorney the entire time to keep my attorney working. So that's even more of a burden on me. And then it sounds like what you're saying is if I were to win, then the most likely outcome is the judge would reward the attorney's fees back. Is that pretty much a certainty?
It's mandatory. Yeah, in a civil forfeiture case, if the property owner wins, the government must pay attorney's fees.
This seems like an area where if you're an attorney that specializes in defending somebody that has had their property seized, that knowing that it's mandatory could charge absorbent fees for their hourly.
So the judge decides what's a reasonable fee. And typically in your scenario, the attorney is doing it on the expectation he's going to get paid, and he knows he's only going to get paid what the court's going to find as a reasonable fee. That doesn't mean that, Elon Musk might not pay some exorbitant fee and not care if his attorney didn't recover it all if he won. But in most cases, that reimbursement is sufficient. That doesn't mean there aren't attorneys who try to game the system and bill exorbitant amounts, but they generally don't recover more than what's reasonable. What's reasonable turns out to be fairly high. I mean, in California, there's a case in California that says a civil forfeiture expert as a defense attorney is entitled to $800 an hour.
I'm going to law school.
Yeah, great work if you get it.
Quick question I wanted to go back to, I forgot to ask. If you have your money in a safe in the car, does that give you any kind of protection whatsoever?
No, it doesn't give you any protections, but it seems to me that it's a good argument to be added to all the other arguments that you are doing this for legitimate purpose, because it's a counter to the argument that nobody carries that much money around because it's unsafe to do so, right? That's what the judges all say. Nobody carries that much money on a coast-to-coast trip because it's unsafe to do that. There are so many safer ways to transport money. Well, you didn't transport it unsafely. You actually had a locked safe. That would seem to me, if I were the prosecutor, I would be taken with that argument as, okay, that's one for your side.
But it's not necessarily going to stop the local police from being able to gain access to it if they wanted to.
No.
Do they need a warrant? I mean, gain access and do they need a warrant are two different things.
Well, that's sort of like Constitutional Law 102. Do you need a warrant to search a car? No. Not if you have probable cause to believe the car contains evidence or contraband. So if the dog alerts or if these other things all add up to searching the car, you can search the car. Do you need to search warrant to search a container that is within the car? It depends. Can he go in the duffel bag? Can he go in the safe? Can he go in whatever else it is? Oh, that's something else we didn't mention before. One of the other factors that they look for is when the driver says, I'm driving cross country, I'm going to be in Las Vegas in 4 days to go gambling. Does he have any luggage? Often these guys say that and they have no luggage. So
that makes sense, yeah.
This is also maybe another strike against us, Joe, because we travel light.
Right.
Yeah, it's true. But we wouldn't have nothing, that's for sure.
No, we wouldn't have nothing.
And there would be car counters who would drive 4 hours to Vegas just because they're too cheap to pay for the plane ticket, for sure.
Yep.
Yeah. Right.
Yeah, we're a cheap breed.
But we should talk a little bit just before we finish about what happens if you don't convince the police officer to let you go on your way with your money. The process involves getting this notice, and you have to respond to it. If you don't respond in the 30 days that you're given, then you've defaulted. It's a very steep uphill road to climb to get your money back if you ignored the notice. You don't need an attorney to file the claim. You just need to respond to the notice within that first 30 days. And then once you respond, then the burden's on the government to move forward. What happens is the prosecutor meets with the police officer and says, tell me the facts of the case. And the prosecutor then decides whether the case has enough merit to go forward. They may kick the case right then and there and give the money back. Often they do. And if they go forward, they file a complaint. And it's at that point that you might want to consider hiring counsel. And counsel gets to decide whether to move to suppress the evidence because the seizure was illegal. Lots of reasons why a seizure could be illegal. They stopped you for speeding, but they kept you an extra hour and a half along the road waiting for the dog to get there from the next state. They can't do that. Everything has to happen quickly. So there are all kinds of reasons they might suppress the evidence. They can move for the return of the money. They can negotiate a compromise, as may have occurred in your friend's case. They can file motions. and ultimately they can ask for a jury trial, then ask for attorney's fees if you prevail. So the reason most defense attorneys don't take these cases based on the expectation of winning their attorney's fees at the end is because in most cases they look at the case and they think this is not winnable because the guy really is a drug dealer. So if somebody has a winning case, then they're more likely to pursue it.
Where can people go to learn more about asset forfeiture law?
I publish a monthly newsletter. It's called the Money Laundering and Forfeiture Digest. Law firms subscribe to it. Almost all the federal prosecutors and federal agencies subscribe to it. And individuals, researchers, academics can subscribe to it. I have a website, assetforfeiturelaw.us, and there's a subscriptions page, and people can subscribe. What would you learn there? Well, it's for lawyers. You'd learn what's happening every month, month after month, in this area of the law, and which way is the law going. And it gives you access to all of my research, which is hundreds and hundreds of pages organized topically on such issues as the burden of proof and the right to attorney's fees and the innocent owner defense and all of that. I'm available if somebody wanted to hire me, of course, but I also have written 2 treatises, one on forfeiture, one on money laundering, that lawyers might find fascinating. Hollywood isn't calling. They're not likely to ask me for the movie rights, but they're out there for attorneys to have as a resource.
So you are open to be hired if we are law-abiding citizens and something goes bad with us. Okay.
And I work with a bunch of other, mostly former federal prosecutors now on the defense side who in various states, whether you're in Texas or New York or California or someplace, who specialize in this. And I'd be happy to make referrals.
Outstanding. Stef, we greatly appreciate your time. This is a topic that, like I said before, it comes up a lot. There's a lot of fear around it. Obviously, there are cases out there that, people are people. There are people that, even in law enforcement, that have nefarious intentions, and just like in any walk of life. So bad things do happen, but it was really good to understand the ins and outs of this from such an expert in this. You, in fact, helped form the policy, which is pretty great to have. So I just want to thank you for your time. It was greatly appreciated.
No, I'm happy to do it because from my perspective, which is, I admit, a law enforcement perspective, it's important for people to understand this because most people who just hear the words asset forfeiture or civil forfeiture are thinking about the cop making a seizure from a motorist and are not thinking about all the other instances where this is an absolutely essential law enforcement tool. Terrorism, cryptocurrency seizures, public corruption, international money laundering, drug trafficking by cartels, the child pornography cases and human trafficking cases. It's absolutely essential in all those areas, and it doesn't help law enforcement to have what they do tarnished by the perception that the tool is being used unfairly, because then you might end up with a baby in bathwater problem where the tool gets taken away and we don't get to use it in all those other cases just because of this perception. So that's why it's important that everybody understand from the law enforcement perspective why it's important and why it's being used, and from law enforcement to understand that there are innocent people out there doing this for legitimate reason, and that they have to make sure they play by the rules and make sure they've got all their ducks lined up before they make a seizure to avoid creating the appearance of something overzealous and improper.
Very well said. All right. Well, thank you so much. And for those listening, as a reminder, everything we teach at Blackjack Apprenticeship is the legal ways to beat the casinos using card counting and math in your brain. To learn more about card counting, go to blackjackapprenticeship.com or check out our YouTube channel, Blackjack Apprenticeship.